who here has a smartphone? I'm probably going to go ahead and say all of you. You're probably going to look at it at least one time while I'm giving the speech. Probably. An average, it probably costs each one of you about, conservative here, about $100. That's materials that probably cost the company about $75. Not too much. But actually that phone is probably worth the technology in it. The design, the UI is probably in the millions. Billions of dollars just in your pocket. And the company spent years investing in these ideas and this technology, and that altogether is quite a legal thing. It's called intellectual property. The term intellectual property is a legal term. It's a reference to the different types of law. There's copyright law, and there's also the law. It protects lots of types of ideas from copy. It protects lots of different forms of ideas. There's also trademark law, which protects brands, and there's also laws protecting proprietary formulas for other things. And so this is of growing importance because many different companies are investing lots of money in this. And well, the reason I'm here is to talk about how the current system is broken. It was originally designed to protect individual inventors who would, on a personal basis, invest money into their ideas and were given a temporary monopoly for a period of about 14 years to protect them and their ideas. But today, however, this is much more complicated, and companies are spending vast amounts of money, as I've said 3 or 4 times. So that's where the real meat of the issue is. And so modern intellectual property law is very challenging. As the original, as I said, the individual inventor is not a thing anymore. It's million-dollar, multi-million-dollar companies who have gone on to take these ideas from the inventor and trade them between each other, and that's one of the problems. And so intellectual property law now, as it exists, stifles invention. And so because the problem is intellectual property laws inhibit the development of new ideas. In addition, intellectual property laws reward companies and not the original inventors. And intellectual property laws are easily exploited. And so the reason it inhibits the development of new ideas is that intellectual property is hampering highly scientific fields. Companies race to new inventions and will stop on a single linchpin idea and patent that as opposed to a larger, more specific thing, just a smaller concept, and that will prevent other companies from developing on that idea for a period of 14 years. And that can be enough to stop all innovation in the field for a couple of years. And intellectual property laws also, as I said before, no longer reward inventors. So the individual inventor can spend up to $20,000 to defend his idea, to just file the patent. And that's, in addition to his own investment in his idea, that's prohibitively expensive. So he can't, a company that would have on file hundreds of patents, they have legal teams to just do this for them. And an individual inventor can't do that himself. And as I said before, they will go after a single idea, and to patent a single idea that's key in the field will limit all inventions in the field, and an individual inventor can't afford to license patents that can go, if he goes to market with his invention, he'll have to pay a percentage of each piece of his sales. And so that is why it's hurting individual inventors. And if he does go to market with his idea and he doesn't get permission from the other companies, it can be millions of dollars again if he tries to go the legal route and contest their interest in it. And lastly, intellectual property laws are, as it exists today, because of the way they were originally created, they're rather vague. It's a recent case about last week. Newegg was sued by a company that was dead. They disappeared. A new company took up their portfolio of patents and sued Newegg for 1% of their gross profits based on the concept that they had a shopping cart for their online retail. And they sued many other companies like Kohl's, a bunch of other online retailers because they had a shopping cart. And this is ridiculous. It's on file in the U.S. Patent Office. The patent they were using is one of about 5,000 others that are identical. They're all exactly the same, filed by hundreds of other companies to have a shopping cart on your online store. This is, any store you've been has a shopping cart. It's outrageous that they can just have it. That's another problem, that the Patent Office doesn't look through these listings thoroughly enough. That there can be 5,000 other identical, literally identical patents. And in 2011 alone, in the U.S. only, it was about $29 billion on patent litigation for not even companies with legitimate contesting patents. It was just companies picking up other patents that no longer are owned by anyone. They're just companies that are either bankrupt or have sold off their assets. They pick up these patents and then sue other companies, even though the previous owners didn't feel the need to sue. Once they pick up these portfolios, they look around for anything that's relevant, and then once they find a target, they'll sue a company for quite a large sum. Even if it isn't a legitimate concern, legal fees are quite extraordinary. And from that, they'll go on and try and, even if they don't have to go to court, they'll try and settle out of court for, once again, large sums of money. And these companies they don't invent, they're just picking up the remains of other companies and suing, even if they don't have a good premise. They can usually get away with about, as you saw, $29 million in 2011 alone. And that doesn't even get into the legitimate cases. One of the most recent ones was Samsung v. Apple. Even something as simple as even on your phone, the slide to unlock, that's owned by Apple. It's quite general, and I'm pretty sure all of your phones you can slide to unlock, Android or Apple, or Windows Phone. So another common patent, which was it's owned by Microsoft. Last year, they made more money on that one patent, which is licensed by Samsung, than they did on Windows Phone, which is extraordinary. Intellectual property law exists today for companies and not inventors.
All right, Daniel, it takes you almost 2.5 minutes to get to the part of the speech where you have the proposition. So you're almost halfway through the speech before you really get to the crux of your argument. I know that there's good stuff in the background that's important for us to understand, but you're going to have to get there a little bit faster, because people are not good listeners. They get easily distracted, and if they aren't focused right away on what the point is, they will wander off. Now, I try to be a better listener than that, so I was listening, and your exact claim is stated, but it's not very clear, and I think it needs to be highlighted a little bit more. You do have a layout of supporting points. This is also, like I said, about 3 minutes into the speech. I think if you just use some numerical signposts on that, they would be a little bit more distinct for the audience to follow as well. You did label that first point when you got to it. I didn't think you were quite as consistent about the other points during the presentation. There's a lot of explanation and description of what your position is on this. What there isn't as much of is proof that that is an accurate reflection of what's going on here. It's not until the 5th minute of the speech that you actually present any evidence, and that's when we get a few examples. Before that, it was very vague, ambiguous hypotheticals. And then we get a couple of examples. You've got the one company that started suing because of the shopping cart. You had the Samsung versus Apple example. And then you had